Good morning. The Senate Committee on State Affairs will come to order. Will the clerk call the roll?
Campbell, Hall,
Here.
Lucio, Nelson, Powell,
Here.
Schwartner, Zaffarini, Birdwell, Hughes.
Here. And for the benefit of the members and those testifying and those that might be watching, there are multiple committees meeting right now and some later in the morning, and some members will be in and out. Their staffs are participating, and when we have the right number of members here, we'll be voting on a bill or two, subject to what was posted. But we do want to go ahead and get started with the agenda. And so at this time, the chair lays out Senate Bill 2233. Recognize our colleague, Senator Menendez, to explain the measure. Good morning, Senator.
Good morning, Mr. Chairman and members. I'm simply the presenter, the senator that gets to present our bill. Senate Bill 2233 is literally our bill. Every one of us has joint authored this bill. And, you know, the simple requirement of this bill is that it requires anyone who wants to be registered to be a lobbyist in the state of Texas to complete a sexual harassment prevention training course and an ethics course. Under this bill, the Texas Ethics Commission will be granted the authority to approve required courses. Members, this is just a first step, a simple attempt to address a deeply rooted systemic issue surrounding the culture in and around this Capitol. And we all agree there should be no room for sexual assault, harassment, or predatory behavior. And in the past, when faced, we have made steps and taken strides where we have required our staff and ourselves to take the very same sexual harassment training every 2 years. We're simply requiring from the very lobbyists who work directly with our staffs many times to do the same thing that we do. Mr. Chairman, there is a substitute, and I will there are very simple changes in the substitute.
Senator Powell, subcommittee substitute. Chair recognizes Senator Menendez to explain the substitute.
Thank you, Mr. Chairman. The committee substitute simply changes the word person to individual in order to avoid any confusion of whether or not an entity would take to have to complete this training. As we know, there has been some court cases where person and individual have been viewed differently. We take the one that says that this is an individual person, not a corporation. Moreover, we're asking that the bill be enacted September of 2021 in order to allow the Texas Ethics Commission time to create a metric in deciding what should be covered in an approved course. Many members, many of you have shared your concerns this week, and we know that more needs to happen to change a culture. But this is a first step in the right direction. I want to thank you, Mr. Chairman, for the setting of this bill and the other good piece, and I want to thank my colleagues, all of you all, for signing on to this legislation. I think it's important that we send a message as a Senate that we not only do not condemn, but we don't condone, but we actually condemn this type of behavior. It's disgusting, it's repulsive, and we all have to remember that so many of our staffs come here with the idea to change the world and do good things. And they should not be subjected to people who have predatory thoughts and want to exercise those. And so with that, Mr. Chairman, happy to answer any questions. We didn't invite any testimony. There may or may not be testimony here. We wanted to respect y'all's time. We know you have a full agenda. It's late in the session. And it's a pretty simple bill.
Senator, thank you for this and for representing all of us in this matter and getting this going. I want to ask you just a couple of mechanical questions about the substitute. You explained it, and I want to make sure I didn't miss anything. Does the substitute change anything as far as the Ethics Commission's authority or their role in the process?
No, the substitute didn't change their role at all. All we say, in even the original bill is filed, they have the authority to approve a course. And in our discussions with many folks, they have said many larger groups already require sexual harassment training. So this may not be a large hurdle for most, or if not some. I can't tell you. All I can tell you is of every registered lobbyist, I would like to see that they have gone through this course. I think that the reality is, and many people have been critical, they're like, well, what good is that going to do? Well, it's going to tell people where the guidelines are. It's going to put people on notice. So, how many times have people, oh, well, I just did this, I just did that. People don't realize that what you think sometimes as just this and that, I was just kidding, I was just playing, that's not right. And so we just want to make sure everyone understands. And, this needs to be a professional environment. And that's what we expect and what we should demand.
Senator Menendez, thank you. Senators, any questions for the author? Thank you for presenting this to us.
Absolutely.
Do you want to close?
I'm closed, Mr. Chairman. You got lots of work to do.
Thank you, Senator. And no witnesses have registered to testify on, for, or against Senate Bill 2223. So I'll ask, just to make sure, anyone present wishing to testify on, for, or against Senate Bill 2233. Seeing none, public testimony is closed. We'll leave the bill pending, but we do anticipate, as members are in and out of other committees, that obviously everybody wants to move this bill quickly. Senator Hall. Oh, I thought you're just getting ready. Never mind. Okay. It's so nice not to have these barriers in between us, and I'm very sensitive to everyone's movement. So,
and thank
right,
you, Mr.
I saw
Chairman,
you. I saw
for making
that.
sure we got the plan. And I do find it, as I was mentioning to Senator Powell here, it seems like we all moved closer together when the plastic came down.
It does.
But that's good. We don't need for it to go back up.
Thank you, Senator Hall. Senate Bill 2233 will be left pending at this time. Thank you, Senator Menendez. And as we move through the agenda, I mentioned many committees are meeting, and Senator Hall is going to have to be in another committee shortly. And so this time the chair lays out Senate Bill 2232, recognizes its author, Senator Hall, to explain the measure. Good morning, Senator.
Okay. Thank you, Mr. Chairman and members. You may remember that at the previous meeting we laid out Senate Bill 1612 with a committee substitute that addressed the issue of moving to a election period. The bill didn't quite fit the caption, and so we have brought back up now a standalone bill, which is Senate Bill 2223. We do have a committee substitute, Mr. Chairman, that we just got a few minutes ago.
Senator Hall sends up the committee substitute and recognize Senator Hall to explain the measure.
Yeah, the only difference with the committee substitute is it's now a Ledge Council version. They didn't make any changes to it. We currently have 3 election processes, which can confuse people as each one has its own unique procedures. These are early voting, mail-in voting, and election day. The differences between what, when, where, and how between early voting and election day provides unnecessary work and confusion for all involved. This bill will simply remove the gap between early voting and election day, creating a single election period. With this change, all in-person voting will be conducted in a single period with a standard process throughout the state. Having a single election period is nothing new or rare, as over a third of the states currently have early voting ending the day before Election Day. This single election period will allow for a consistent and uninterrupted time frame for voters to vote in person, as well as opening the door for more and greater checks on the integrity of our election process. Having a single election period would allow for booking with a complete printing of 0 tapes immediately before the opening of polls at the start, and printing of tally tapes immediately upon the conclusion of voting on Election Day, the last day of the voting period. Both the 0 and tally tapes would be signed by the presiding election judge and an official poll worker of the opposite party. The 0 tapes will demonstrate that no machine has had any votes entered prior to voting, while the tally tapes will provide a record of how many votes were cast for each candidate or ballot measure on each machine. If a machine must be removed due to malfunction, it must be kept in a secure and isolated location. Making these changes will allow for greater opportunity for voters to vote while simultaneously restoring confidence in the accuracy and outcome of our elections. Finally, this bill will include a study by the Secretary of State's office to dig really deep and develop a comprehensive plan. This in turn will also allow the counties to realign their procedures with a single voting period. Mr. Chairman, I'm happy to take questions, but I will tell you also we have been working with Secretary of State's office on this and have incorporated some of their suggestions in the bill that I believe we may talk about when we call them up. I think that I'll take any questions at this time.
Senator Hall, thank you. Any questions for Senator Hall? And Senator Hall, this has been something you've invested time and talent in and brought people in, and thank you for leading us through this. Would you like us to call Mr. Ingram from Secretary of State's office initially to have the discussion?
Yes.
Very well. We have as a resource witness Keith Ingram from Secretary of State's office. Counselor, you come on down and get set up here. Welcome. It's good to see you. You know how to do it. Introduce yourself, tell us who you represent, and we'll get started.
Excellent. My name is Keith Ingram. I'm the Director of the Elections Division at the Texas Secretary of State's office, and we are here on Senate Bill 2232.
Senator Hall.
Okay. Mr. Ingram, I think we've gone over some of the things. You suggested that we make this effective with the 2024 election to make sure we've got time for people to, a lot of minds that out there that this is not the way we've done it in the past. And so it'll be a change in kind of paradigms for folks. Would
Exactly.
you want to talk about some of that for us?
Sure thing. This is certainly a doable change, and we just want to make sure that when we make this switch over, that it's been that we've thought about all the code sections that would need to be updated and presented those to the legislature, so that everything can be done in the best possible way.
Okay. And this is over the years, we've been doing elections for a long time now, and as we progress, technology changes, things change here and there. We've added, deleted code, and so we kind of have a patchwork of election code that's spread throughout lots of places. Some very significant, others not so.
Right.
And I believe you suggested it's going to take a while to go through and get code aligned with what is a simplification of the process.
I agree with that. We've got, like you said, 3 separate election processes now, and we're going to be melding 2 of those together, so it will take a little bit of time and study and thought to do it properly and well.
Okay. And with that, we should be able to have, so that the confusion exists with people, well, we do it this way for early voting, but we do it this way on election day, and when does it begin, when does it end, or when is election day? Those things that confuse people will go away with this.
Should go away, yes, sir.
So there's no, as we talked about it, I don't think we could come up with a good reason for having the 3-day gap between the two, and certainly the issue of learning the results of early voting serve no purpose in the election process other than information for people to say, oops, we're ahead or behind.
Right. I agree with that.
You would agree with that?
Yes, sir.
So we're not making a change that's going to affect elections per se. It'll be pretty much the same as what we got, total vote at the end. And what this does do, and as the question has come up over time about the tally tapes and the problem we have when we have early voting of not being able to run the tally tapes after early voting because of the exposure of election results. And that's developed a lot of angst with some people, particularly you have a 4-day period there that not sure what happens. So this now allows us to be able to firmly box in what happened at the precinct level, right there at the precinct level, with the 0 tapes being printed just before the polls open and the tally tapes right at the end.
Yep.
it answers a question that a lot of people have had. Would you agree with that?
I would, yes, sir.
Okay.
Absolutely.
So with that, I think, look forward to working with the Secretary of State's office to refine this. We'll come back with their plan next session to see if we need to make the other changes we would need to make to legislation to pick up all the ancillary things that are spread throughout the code.
I agree with that.
Thanks, Mr. Hall. Mr. Ingram, let me ask you a couple more along those lines. Historically, as far as how we got here, my impression is that, of course, Election Day has been Election Day for some time, and then when Texas decided to add early voting, that was created as somewhat of a separate animal before Election Day. But help us understand the dichotomy we have between Election Day and early voting and all the differences in the code. Is that just a historical relic of the way we had Election Day first and added early voting? I may be wrong, but help me with that.
No, that's exactly what happened. We had, Election Day all the way up until the late 80s, and then they put in a new part of the code that's just about early voting in person. And of course, those provisions have changed over time. But, early voting in person has got a separate way to come up with election workers, and Election Day has its own process for election workers. So those two are going to have to be melded together. Early voting is solely the province of the counties in the primary election, but Election Day is the responsibility of the state for payment. So we're going to have to come up with a way to separate those costs.
Okay.
So there are things that we have to think through to make sure this is done well, but it can certainly be done.
That's helpful. That's good to know. My impression is, at least in some counties under the current system, the machines that are used for early voting are different from the machines that are used for Election Day. That is, many of us may have thought or assumed that after the end of early voting, those machines at those polling locations were removed and placed elsewhere, or maybe repositioned for Election Day. But I think I've learned that, in fact, they are different machines. But help us walk us through that.
Absolutely. So yes, in early voting, the machines that are used are locked and sealed differently, because they've got two locks, one by law enforcement, one by the election clerk or early voting clerk for that election. And so they are stored and sealed during that 4-day window between early voting and Election Day, so that they can't be tampered with. And then the votes are read off of those on Election Day. They're counted. The votes are counted during Election Day while the election is proceeding. So it's a completely different set of equipment than what they use for Election Day.
Are the machines technologically different, or they're just programmed differently for those different uses?
They're programmed the same. They're the same equipment, but the votes that are cast on them are segregated from Election Day votes, and so they have to be kept separate.
Okay. So then, after the implementation of 2232, we could have more machines available for voting. It sounds like, instead of having to separate out Election Day machines from early voting machines. Does that make sense?
It does, and we would have to think about, because we've got about 77 counties that do countywide polling, and so it would be a very seamless transition for them from into 1 day of voting from early voting. For the ones that have precinct level elections on Election Day, it would be more difficult to make the transition from a few early voting places to all your precinct polling places. But it's certainly not undoable. It's just going to have to be thought about.
That makes sense. As far as the implementation, you've already talked about this, Mr. Hall, but going through the code and, of course, working with the counties and all the adjustments that have to be made, you feel like this gives you enough of a glide path to get it switched over?
Absolutely.
Very good. Very good.
Yeah, we'll have a report back by September of 22, well in time for the next session.
Very good. Thank you very much. Senators, any other questions for Mr. Ingram? Great. Thanks for being here.
Thank y'all.
Okay. Thank you.
Thank you. The chair calls Chris Davis on Senate Bill 2232. Speaking of county election officials and how that process works, come on down, and you've done this before. Introduce yourself. Tell us who you represent. Welcome.
Good morning, Mr. Chairman, members. Chris Davis on behalf of the Texas Association of Election Administrators, testifying on the bill. This is quite a substantive bill with massive changes potentially to how what's in the election code, as Mr. Ingram and his expertise testified to, but the actual practical realities on the field of how to conduct elections. The chairman mentioned as much when this kind of language was out of the blue introduced to one of your previous bills earlier in the month. We'd like to see this bill focus on the feasibility study. Focus on the feasibility study without any kind of, feasibility study, and then it's going to happen in 2023. Because as I sit here, hand to God, we don't know what the effects are on the practicalities of conducting elections, adverse or beneficial. I don't think the SOS and their attorneys know either. It could be great. We want to know. We'd like to see this study. We hope it's not just so tally tapes can be printed after a solid period of election. That's the only reason to fundamentally overhaul the entire election process in Texas. Their concerns, and we hope that the author and supporters of this bill consult the election officers in those counties, in Dallas County, in Kaufman County, in Rockwall County. Chris Lynch is a great EA, and we hope that they're consulted throughout this period of the feasibility study by the legislators, the lawmakers that want to see something like this. We're certainly not saying no. We're saying could be a good idea. We have no idea at this time. We want to see the feasibility study. We want to participate in the feasibility study, but to say, let's do a study, and we know it's going to be great, and let's implement this in 2023, from where we stand as subject matter experts of conducting elections at the county level, is a bit premature.
Thanks for your testimony, Senators. Senator Hall.
You do understand that there are 21 other states that currently do this?
They are, sir. And if that's the kind of argument we want to use, other states do a thing, why don't we do it? Ballot by mail voting, county, statewide, automatic voter registration. Their laws and the way they conduct elections at the ground level are also fundamentally different than how we conduct it. And their voters are accustomed to a fundamentally different way of elections than we are. I'm not saying no, Senator Hall. I'm saying this warrants a study, and then let's see what we come up with afterwards.
Okay, and I think what we're talking about in the study primarily here is because we have such a patchwork of code out there that people are following because it's code that's been put together over a number of years. The main reason for doing this is going to take a while to find all of that stuff. We're here at the end, nearing the end of this session. Possibly if we had gotten this started a little earlier, we could have gotten further along with it. But the practicality of it, it could probably be summarized as saying this is no different than to say the last day of early voting was election day.
I'm sorry, sir, I can't agree with that. Elections conducting at the county level are a little bit more nuanced in saying the practicality is an afterthought. It's not, in our opinion, it's not that simple and straightforward.
Okay.
Thank you, sir.
Senator Powell, any questions? So, Mr. Davis, thanks for your testimony. Let me ask a couple of things. Were you here for Mr. Ingram's testimony?
I was.
I thought so, but I
raced up from the one right below us. Thank you for having it in closer proximity. Appreciate that greatly.
I know what you mean.
Got my steps in.
Yes, sir. You're welcome. Thank you. We try to help it. Thanks for being here. Do you? We were talking about the history and why we do election day and early voting, and I think you and I probably both started voting after we already had early voting and election day. Most in this room probably did, but do you have a sense for that? That what I'm saying is his recollection was we've had election day for a long time, added early voting at some time, so that's at least one reason why the two systems grew up separately.
Yes, sir.
What about that? Does that make sense to you?
It does make sense. I'd love, and I'd probably need to go back and see how gradual or elaborate was that implementation of early voting. Was it feasibility study and in the bill we're going to have it, or let's take a look at it? Let's see both at the state level with election code experts, which they are at the SOS, and on the ground level experts in the county, how does that early voting period work and how gradual or was that implementation? But I agree, it did happen, and I don't think there are regrets on any level. Yes, sir.
And as you know, Texas has, contrary to all the stuff in the national media, Texas has one of the more generous early voting in-person systems. Wouldn't you agree with that?
I think we're at the cutting edge, forefront of that. Yes, sir.
Well, thank you very much. Any other questions? Thanks for being here.
Thank you, Mr. Chairman. Yes, sir. Senator Hall.
The chair calls Ryan Cox. Ryan Cox. Give her a second. Good morning. She'll get your spot ready there. Hang on just a second. Well, you have some paperwork for us?
Materials for the committee.
Very good. Very good. Yes, sir. Taryn will get those from you. Thank you very much. Welcome. Have a seat. Get situated there and introduce yourself. Give us your testimony. Good to be here. Good to have you.
Good morning, Mr. Chairman and members of the committee. My name is Ryan Cox. I'm a senior attorney in the voting rights program at the Texas Civil Rights Project. I'm here testifying on behalf of TCRP. We registered in opposition to this bill primarily because of the insertion of Section 2C into the bill, which we believe doesn't have anything to do with the primary purpose of the bill of combining the early voting period and election day. That piece we don't necessarily have a particular problem with. But Section 2C does something different. Attached to my written testimony is an analysis of its effect. The result is every affected county would be significantly would lose significantly more polling places or add polling places in predominantly Anglo districts than in districts populated by people of color. The bill takes advantage of lower voter registration rates and historically discriminated against communities of color, which are the direct result of centuries of intentional legal discrimination, such as the Secretary of State's voter purge in 2019. In Bexar County, for instance, HD 118 is geographically the largest district with a high Latino population and many voters without vehicles. Yet voters in this area would have 6 times fewer polling places per square mile than voters in predominantly Anglo and affluent HD 121. So this particular provision of the bill requires that polling places be distributed evenly across House districts without taking away local control of election officials to determine the needs of the local communities. So, for example, in House districts where there's very low availability of transportation, people that have vehicles far less often, or when they're much, much bigger, because they might be sparsely populated compared to like a tiny rural district, urban district, this piece would require those polling places to be evenly distributed anyway, and takes the control away from the local officials to determine what the needs of the community are. And it also, on top of that, ignores the fact, like Mr. Ingram said, that many counties, including all 5 of the counties that would be affected by this provision, now use countywide polling, which means that a lot of people don't even actually vote in their home precinct anymore in these counties. I think Bexar County estimated in the 2019 congressional constitutional amendment election that about half of voters actually voted outside of their home precinct, which means this actually doesn't even affect providing additional polling places where there are actually more voters. People are voting where they work, they're voting downtown, or they're voting next to like large corporate headquarters where they might work, but there's very few people who live in those places. So taking this particular piece away from local control would negatively affect the experience of voters, but also is likely to violate the Voting Rights Act for the disparate impact on minority voters that is outlined in the written materials I provided to you. That's all. Thank you.
Thanks for your testimony. Any questions, Senator Hall?
Mr. Chair, I would say that this particular section was put in here to maintain consistency with what was in SB 7. And I think as we went through Ledge Council, they wanted to make sure that the two were consistent. And that's the only reason for that being in here as a part of this is to maintain consistency with SB 7.
Right.
Was in there.
I see what you mean.
Okay.
And Senator Powell, any questions from you? Let me ask, and thank you, and we've got your testimony, and thank you for working through that with us. And we know that's a discussion we've been having about polling places in urban counties and being distributed fairly, and fairly is in the eye of the beholder. We get that. That'll be an ongoing discussion. And so we have your position against the bill. I'm not trying to change that. Let me just ask the issue. I think you said this, but the issue broadly of combining early voting with voting, having a voting period without the gap in between. If you have a position on that, I'm just curious, not this bill, but as far as the concept goes, subject to the details, as far as that concept, what do y'all think about that?
Like the person who testified before me, we haven't really done kind of the analysis to see what it would really mean for voters, but I can say from me personally and not on behalf of my organization, to me, it seems like it makes sense and would actually cause less confusion among voters. So, me personally, I think that that's a decent idea. It's the insertion of this separate part of the bill that doesn't have anything to do with that we have a problem with.
No, thanks for that. And you made that comment about confusion. Senator Hall talked about that too. I know a lot of us, I bet a lot of us in this room do door-to-door campaigning, us for our campaigns and for others, and people saying, now, when does early voting end and it is confusing, I know, to folks. And, okay, thank you. Any other questions for the witness? Thank you for your testimony. The chair now calls Bill Sargent, who knows something about conducting elections. Bill Sargent, let us get this space ready for you, Ms. Sargent. Yes, sir. Welcome. You've done this before, but introduce yourself and give us your testimony. Good morning.
My name is Bill Sargent. I'm the former Chief Deputy Clerk for Elections in Galveston County. And I was, based on the colloquy that you and Mr. Ingram had, I want to change my position on what I'm testifying on from on to in favor of.
Oh, very good. Thank you.
Okay.
We'll note that. Thank you, Mr. Thank you.
The past witness just talked about that section that I had a comment on, Mr. Hall. Harris County has a tendency to front load and put lots of polling locations in Democratic areas, and sparsely in the Republican areas. That's why that was prepared originally for SB 7. That needs to stop. We need to have fair and equal treatment for everybody. Not based on color, not based on party. Everybody needs to have access to the polling place, and so that's what that's for. Now, I was in touch with your staff, James, and I talked about a couple things there. One is that one thing that might make sense would be for counties under 1 million that you continue what we do for early voting currently, which is you do it on commissioners' districts, and no commissioner's district can have more than twice as many as the lowest number. So you might want to consider that. The other thing is that you changed the dates on the study and the other, and I'm not sure exactly what you've done in your substitute, but you need to have more time between the study and the report, because it says the study has to end by, in the original draft, by September 1st, 2022, and then you have to have the study refining report by the same date. You might want to give yourself 3 months or something to have the study actually prepared. I don't know if you've done that already or not.
We do. This is going to be, by the time we come back to the next session, we will have their input on it, and this doesn't get implemented until the following election period, which will give us a chance to modify this if we need to.
Great.
And the idea for going ahead and putting this in as being implemented is so the mindset is working towards how do we make this work, as opposed to spending, the next couple of years trying to decide whether we're going to do it or not in there. And certainly if the study came back with some kind of a huge problem, insurmountable problem, the next session we would be able to address that and make the appropriate changes. But in order to make it happen, and I think it is a bigger mental change to people moving from, well, we just don't do it that way, not because it's required. That's just not the way we do it. They're doing it something different. It gives them more time to adapt. And when they figure out that all we're doing is saying the last day of early voting is now election day, that's all this bill really does.
Well, my hat's off to you for thinking outside of the box.
Yes, sir. And honestly, there are a number of folks I have talked to that really have said exactly what you did. Didn't like it at first because that's not the way we do it, but after they think through it and realize how it simplifies things for people and makes it easier and probably will get more people out to vote, they say, gee, that's a pretty good idea. So.
Well, if I could take the time, two things. I showed James a copy of the zero tape and the tally tape on the new equipment, and that can be done just like we talked about. We're a countywide voting center in Galveston, but I showed him examples of how that could be done, and done not like I did it in November of 2012, where it took 3 hours for the polls to open, because it ran 16,000 zeros. That doesn't happen now, so that's good. The other thing is that I have been an election official, and the person who spoke previous to me here earlier, I don't think it's going to be a problem And I agree that you ought to take a look at it and what happens. And as you said, the next session we can tweak it if need be. But the bottom line is, this is something to go after. It's worth doing, and I don't like the negativism. I can't say the word, but yeah, you know what I mean. The bottom line is that this is a way forward. It makes sense. It gives you more machines, like you were talking about, Mr. Chairman, and it's really worthwhile looking at and doing. So I support the bill.
Well, thank you. Yeah,
Yes,
I
sir.
think the time is because we've got election code spread in so many different, in little ways all over the place, and it was written originally for paper ballots, then came along DREs, and then we got some other changes that were made and so on, that we'll make sure we get all the, it's really the time is to make sure we get all the legal part cleaned up so that it's consistent, or some doesn't come back. So I can't do that because of section so-and-so over here that won't let me do that, or
Yes, sir.
requires me to do this. It's not something functional or physical or insurmountable to kind of do it, because it comes back, as I said before, all this does is now treats it as though the last day of early voting is election day.
Yes, sir.
But thank you for your testimony. Appreciate it.
Thank you.
Any other questions, Senators?
Thank you for letting me testify, and appreciate all the members being here, and also the staff, because I know they work very hard for you all.
They do.
Thank you.
Thank you for being
Thank you
here.
for your input.
Those are all the witnesses who've registered electronically to testify. I'll ask if we have anyone else present wishing to testify on, for, or against Senate Bill 2232. Seeing none, public testimony is closed at this time, and we'll leave the bill pending at this time. The chair now lays out Senate Bill 2011. Recognize Senator Menendez. Welcome back, Senator.
Thank you very much.
Recognize you to
Mr. Chairman.
explain the measure.
And I know that you all have a place to go. I just wanted to ask you for 2 minutes of your time, because this is a bill we've been working on for a long time. And many of us have talked a lot in other committees about a lot of the issues that our kids are dealing with. And many times, I can tell you, when I've been sitting with one of my teenage children, I said, it'd be much easier to be your friend, but God gave you 2 parents, and I'm not going to take one of them away from you. This bill's about when one parent tries to take another parent away from one of their children. Members, custodial interference occurs when a parent disrupts the custodial rights of the other parent to the degree that disruption causes denial of access. And this occurs all too often. In many cases, parents are driving 3 to 4 hours to see their children, where the court orders give them maybe once a month visitation, and yet they're denied access by the custodial parents. And there's confusion amongst law enforcement. Here, the person has a court order. The judge said, I get to see my child on this day at this time. So they call law enforcement, and law enforcement says, I'm sorry, that's a civil matter. And they deny them. What this bill would do, it simply would address the issue by requiring a peace officer, who are very often called to these exchanges, just to determine, ma'am, sir, is the child here? What's going on? And if not, submit a missing child report if they don't know where the child is. And the reason is this: the peace officer, by writing this report regarding the incident under the articles with the details of the event, would allow for the use of that potential court order. It's proof of the order not being lived up to. The bill will also grant an affirmative, this is a legal term, that defense to prosecution if the parent who didn't know where the child was, all of a sudden they can say, they can prove, hey, it was due to something beyond my control. The child was with grandma, granddad, they were at school, they were sick, they were at the doctor, I had nothing to do with it, or they were promptly notified, or they were immediately brought forward. We don't want to arrest anybody. I don't want any custodial parents arrested. I will tell you this, though. Many people have been abusing this system, and there are people in certain counties that the constables who've been called have said, ma'am or sir, if you don't let your children follow this court order and go with the non-custodial parent, I may have to arrest you. At that moment, they comply. I'm not asking for that. All I want is for the children not to be deprived of access to their parents. Because it doesn't just affect the two parents who, for whatever reason one of them is trying to use the children against the other. It affects the children. And I've been working on this for a long time. And the one time, the Zoom that we had recently that really broke my heart was an young adult, who told me the stories about how she never received the birthday cards that her dad sent, and how the gift cards were stolen, and how she was told that her dad just didn't want to see her. And she grew up with so many self-esteem issues, and she's had problems of her own. And she is angry because no one stepped up to help her have the court-ordered relationship with her father. And so all I'm saying, folks, is let's help law enforcement clear up some ambiguity. Let's get a report so that the judge's court order can be honored. This is about law and order, and it's about simply allowing for both parents to be in the lives of the children. Simple bill.
Senator Menendez, thank you for this bill. Any questions, Senators, at this point for the author?
I appreciate you hanging out. I know you have another committee to get to. I appreciate that. If you don't have any questions, I know there are a few people who've been waiting a long time to testify. And what gets to me is when they don't pay their child support, we appropriately beat them over the head, throw them in jail. We we send the attorney general after them. You need to pay that child support. When these folks are doing everything right and all they want to do is see their children, we're not there for them. Mm-hmm. At least the law is not. I know we can step up and do the right thing. Thank you.
Thank you, Senator Menendez. We'll open testimony, and the chair calls Derek Berry. Derek Berry. Mr. Berry, come on down. We'll get this space set up for you. Okay. Thank you. Welcome. Have a seat there and introduce yourself. Tell us who you represent and give us your testimony.
For the record, my name is Derek Marshall-Berry, Reverend Derek Marshall-Berry. I am the Communications Director for Texas 2503, Interference with Child Custody. I am for SB 2011. Mr. Chairman, Committee, on behalf of Texas parents everywhere, I thank you for your tireless efforts and the opportunity to speak today. Texas parents, despite having a valid court order deemed in best interest of the child by a judge, mothers and fathers, custodial, non-custodial, face access issues when trying to exercise their possessionary time, with truly little to no enforcement at their disposal. All too often, they're told by frontline law enforcement it's a civil matter to go back to court, when indeed interference with child custody under Texas Penal Code 2503 is a criminal state jail felony. SB 2011 does a few key things. It outlines the process for law enforcement. It aids in the documentation process to demonstrate the pattern and alienating behavior from the offending party, and the parents are no longer turned away empty-handed without child and or a report documenting the infraction. It also adds a level of transparency and accountability towards the alienating party, frees up law enforcement resources in the long run to be utilized elsewhere, also aligns SOP standard operating procedures currently being deployed with the Texas Penal Code, provides a reasonable solution for Texas children to have access to both loving parents, solidifying the Texas Children Bill of Rights, joint managing conservatorship, and loving and caring orders, which are often embedded in common practice in custodial agreements. It is with great hopes that SB 2011 serves as a deterrent from that repetitive alien behavior, and we no longer tell parents who are financially, physically, and emotionally exhausted it's a civil matter. It provides them a solution. May God bless you on your tough decisions ahead, and God bless Texas.
Thank you for your testimony. Senators, any questions for the witness? Thank you for being here. Thank you for sharing this with us. The chair calls Lindsay Irwin. Lindsay Irwin. Ms. Irwin, welcome. Have a seat there. Get situated and introduce yourself to us and give us your testimony. You're welcome.
Good morning. My name is Lindsay Irwin. I am the lead research for Texas Team 2503 and the Assistant Director of Operations for the Fathers' Rights Movement. I got those positions because I was the child that this bill is intended to protect. If you are wondering, if you have any doubts about this bill, I am telling you we need this. I am telling you that our justice system needs this. When a crime is committed against a child, a victim impact statement is needed for the process to determine how that child was affected and impacted. I will never get the opportunity to tell you how deeply impacted I have been by my childhood, by the retention of my father being alienated from me for 20 years. This didn't stop when the court order extinguishes. It doesn't stop when I turned 18. It didn't stop when I graduated high school. This affected my children because he didn't get to meet them until they were much older. The end of the day, what this bill does is it gives law enforcement instruction, it gives them resources, it gives them backup. It gives them the ability to do their job in a uniform sense. I heard other testimony on other bills about broken code. This code needs a little oomph. I worked very closely with Senator Menendez's office. I even submitted a draft to his office. I have got a lot of investment in this bill, and I'm asking you guys to favor this bill. I'm asking you to pass it as quickly as you can. We have children that are being affected. Today, when I leave, I will drive 4 hours to help a father try and obtain an offense report, which he will very likely be denied. That's how serious this is. This is happening today. So I ask you to please vote in favor of this.
Thank you, Ms. Irwin. Is there any questions for the witness? Thank you for being here.
Thank you for the
very much.
opportunity.
Of course. The chair calls George Saldana. George Saldana. Saldana, come on down. You have some paperwork for us?
No, sir, not at this time.
Okay, no problem. Just making sure.
Just an exhibit.
Oh, very good. Exhibits are good too. You get situated there, and then that's right.
This is called the box.
We understand. If you don't mind, would you remove your mask so we can understand you better?
Yes, sir.
Thank you. Introduce yourself to us and tell us who you represent. Give us your testimony.
Good morning, and thank you for letting me testify. My name is George Saldana. I represent children being denied access to their parent with a valid judicial order, and for Texas Team 2503. I am for Senate Bill 2011. I am the founder of the grassroots organization Texas Team 2503, Interference with Child Custody Group. The main issue is that Texas children are being denied access to mom or a dad against a judicial order with zero relief. I would like to provide you statistics to show you how the legislator and law enforcement have a disconnect about this issue. The legislator makes the laws and law enforcement enforces these laws, except law enforcement is not following or enforcing the current state and federal laws. This is how parents start to lose access. Children excel when two parents are involved with their lives. When two parents are involved, children are 80% less likely to end up in jail. Teenage girls are 75% less likely to get pregnant. 91% of Texan non-custodial parents are men. 90% of teen runaways come from fatherless homes. A third of those 90% of the runaways are high risk to be sexually trafficked within 48 hours or less. In San Antonio, Texas, a public information request from the San Antonio Police Department reported 12,354 visitation violations in 2016. And this is what it looks like. In 2018, the number rose to 13,196. 2019, 13,038. In 2020, Team 2503, working with local political leaders to bring awareness to the Bexar County area, we saw these numbers decline to 11,718. In closing, we have laws that are legislated to protect the public, and we have police to enforce these laws. Children need enforcement to preserve the parent-child relationship as deemed in the best interest of the court. The legislator in the past has done a phenomenal job in staying current with this law legislated in 1973. It would be awesome if y'all could push this bill as time is of the essence. Thank you for your time.
Thank you for your testimony. Is there any questions for the witness? Ms. Saldana, thank you for being here.
Thank you.
Very much. Is there anyone else present wishing to testify on, for, or against Senate Bill 2011, 2011? Hearing none, public testimony is closed. We'll recognize the author to close on the bill.
So, Mr. Chairman, I'll be very brief. I've met with lots of law enforcement officers. I've met with lots of suburban chiefs. They're all begging for some clarification and some help. They've all told me they can set their watches by the month when these visitation orders come up, and they're all getting the calls, and it's just taking up a lot of time. And they'd rather not be involved. And I hope, and I know that every one of y'all want the best for the children of Texas, and so I hope we can give some clarification. Thank you, Mr. Chairman.
Senator, thank you for bringing the bill to us, and bill be left pending at this time. Thank you. Can you recognize me? Oh, yes, sir. That's a good point. And the record will reflect that Senator Schwartner is present. Thank you, Senator. Thank you. So 574, 574. Lay it out and have witnesses out in the vote. So 574, House bill.
The chair now lays out House Bill 574 and recognizes Chairman Hughes to explain the bill.
Thank you, Madam Chair. I'm pleased to present this bill that comes to us from the House, and Representative Bonin and our colleague Senator Larry Taylor is the sponsor, and on his behalf I'm laying out the bill, so thank you very much. This bill passed the House on April 15th, and it adds potential fraudulent activities related to the counting and reporting on the count of a vote. Adds this to the election code. It seeks to prosecute these offenses at the same level as other fraudulent activities that affect the number of votes represented. This is obviously important stuff that needs to be addressed in the election code. And Madam Chair, we do. That's what the bill does. We have a resource witness here. Can tell us more about it. It's an important bill that we bring on behalf of Senator Taylor.
Okay. Well, I have no questions. We will now bring the resource. Do you want the resource witness? The chair asked the resource witness. I don't have his name.
Madam Chair.
Keith Ingram.
And Madam Chair.
Thank you. Yes, sir.
I apologize. I should have read here in plain English that there is a committee substitute.
Oh, then hold up.
I can send that
Mr. Ingram. The chair now sends up committee substitute for House Bill 574 and recognizes Senator Hughes laying out a bill for Senator Taylor.
Thank you, Madam Chair. The election code doesn't directly address situations where an individual intentionally alters a report to misrepresent a vote count. And cases like these would be rare, but the charge would be fraud or forgery. They don't really fit neatly in the code. The committee substitute for House Bill 574 adds counting invalid votes or refusing to count a valid vote in an effort to alter a report. It adds that offense to the election code, would establish the penalty for such offense as second-degree felony. This is the penalty already for illegal voting in Chapter 64, where an individual intentionally casts a fraudulent vote. That's what the substitute does.
Thank you, Senator Hughes. The chair now calls up Keith Ingram. If you would, state your name for the record, of course, and who you represent. Thank you for joining us.
My name is Keith Ingram. I'm the Director of the Elections Division at the Texas Secretary of State here on House Bill 574.
Thank you. Would you give your opinion about this bill and any clarifying information that you think would behoove us to know?
So the bill, I think, is common sense. We don't want people to knowingly or intentionally try to alter the outcome of an election by counting invalid votes or not counting valid votes.
Okay. Anything, as you've looked at this bill, that you see would be a problem?
There The section that this is in, 276.013, has an escalator provision so that if it involves voters that are over 65, that it goes to the next higher level, which would be a first-degree felony if this passes into law. I think the committee substitute was supposed to take out that escalator. So if that's done, then I think we're in good shape.
Good shape. Okay. Senator Hughes, do you have any questions?
Oh, thank you very much.
Thank you very much, Mr. Ingram.
Thank you all.
The chair now opens public testimony for committee substitute to House Bill 574. The chair calls up Valerie DeBille. Thank you, Ms. DeBille. If you'll remove your mask if you don't mind. State your name for the record and who you represent. Thank you for joining us this morning.
Hi, I'm Valerie DeBille, testifying as a member and on behalf of the League of Women Voters of Texas in opposition to HB 574. We appreciate your attention this morning on the League's position on this bill. We oppose HB 574. Just as we testified in the House Committee considering this bill, we believe imposing these criminal penalties could have a chilling effect on the willingness of individuals to assist a vote count. For example, Section 65.009 of the Texas Election Code requires evaluation of the voter's intent when a ballot is irregularly marked in order to determine if the ballot should be counted. This evaluation is necessarily based on a review of the entire ballot that, understandably, may result in disagreement. Changes in the statute proposed in HB 574 could turn discussions over disagreements into threats of imprisonment. Citizens may be unwilling to serve as counting officers if fulfilling their duties subjects them to possible criminal liability. We urge you not to support HB 574. Thank you. Questions?
Thank you, Ms. DeBille. And Senator Hughes, Senator Powell, do you have any questions, either one of you? Thank you very much. Seeing no questions, I do not see any other people wishing to testify. Is there anybody else wishing to testify on, for, or against committee substitute House Bill 574? Hearing none, public testimony is now closed. Are you going to lay out your other?
Let me see if Senator Powell's okay. Senator Powell, you need to get going in terms of, we can do yours now, or I can do mine while she's got the chair. But are you okay with time? Okay. Madam Chair, why don't we, could we do that, could we do page 67?
Yes, sir.
Ms. Thompson?
The chair now lays out House Bill 867 and recognizes Senator Hughes to explain the bill.
Thank you, Madam Chair. I'm pleased to sponsor this bill that comes to us from the House and Representative Thompson. This did pass the House 145-0 on March 25th. Under federal law, child support and spousal support can be paid via a qualified domestic relation order, often called quadros. These orders are used to retrieve funds from retirement accounts. The Texas attorneys and the Child Support Division of the AG's office have historically used quadros for this reason, to get this access. But there's been some confusion about whether state law is aligned with federal law, since these are federally controlled retirement accounts. House Bill 867 clarifies and aligns Texas law with federal law by providing for quadros to be used for the payment and collection of both child support and spousal maintenance. This has been done for years under federal law, and that's what this bill does. In the version that before us today comes from the House with a floor amendment that clarifies no provision in this bill that conflicts with federal law or the law that governs public retirement systems. That's what the bill does, and I yield for your questions.
Thank you, Senator Hughes. I have no questions. Is this a resource? Senator Powell, do you have any questions? All right. Seeing no questions, we do have, we will now, is this a resource witness?
But I think he's...
Okay. We will now open public testimony, and the chair calls up Joel Rogers. Joel Rogers. Good morning. Please state your name for the record and who you represent.
My name is
Position
Joel
on the bill.
Rogers. I'm the Associate Deputy Attorney General for the Child Support Division of the Attorney General's Office, and I'm here as a resource witness. This is a direct response to a Supreme Court case which questioned whether or not the Family Code had sufficient authority for both spousal support, spousal maintenance, enforce spousal maintenance through quadros. And it also raised some questions as to whether there's sufficient statutory authority to collect on child support through a quadro as well. The Child Support Division has been using quadros for about 15 years to collect child support. We generally collect about $2.5 million a year using quadros. We don't file a lot of them, but when we do, it's usually a lot of money for that family. And we certainly would, this bill would certainly ensure that we can continue to use quadros to collect child support. I'm happy to answer any questions.
Members, any questions? Thank you very much. Is there any, I see no other witnesses listed. Is there anybody else wishing to testify on, for, or against House Bill 867? Hearing none, public testimony is now closed. The chair now lays out House Bill 918 and recognizes Senator Hughes to explain the bill.
Madam Chair, thank you. I'm pleased to pick up this bill from Representative Lamont over in the House. We all know of accounts, maybe we've even had friends or family members affected when victims of abuse have taken those steps necessary to get a protective order, but of course that wasn't sufficient. It didn't protect them. It didn't stop the abuser from breaking the law and harming, even taking their lives. And so, in fact, we know in 2020 that 7,318 arrests were made in Texas for violation of a court order, and they tell us that most of these arose from violation of protective orders. One study said that 40% of these violent orders are violated, and 20% of those involved escalated violence. And so the bottom line is that a protective order can do only so much, and someone bent on causing harm can still cause harm. So right now, if someone, under current law, if someone's 18 years of age, they can own and possess a handgun, but they're not allowed to get a license to carry until they're 21. So folks who are needing protection from an abuser and even have a court protective order in place, if they're under 21, they're not able to legally carry a firearm to protect themselves, a handgun. So House Bill 918 would allow a person who's been granted a protective order and who's over the age of 18 but under 21, allow them to apply for a concealed carry permit the same way someone does over 21. And they could have that permit through the duration of their protective order. The license to carry would be valid until the date on which the court order is rescinded or when it expires. It'd be a protective order designation on the face of the license so that officers could tell what it was. And this is about giving victims the ability to protect themselves, the tool they need. It might be the only thing they have to prevent them from being abused further and even their lives taken. That's what the bill does. Proud to present it on behalf of Representative Lamont, and I'll yield for your questions.
Members, any questions? Hearing none, we do have one resource witness if we'd like to have him called up, Steve Moniger from DPS, but at this point, do we need him? Okay. The chair now opens public testimony and calls up Angelica Halpin. Angelica Halpin. Next, after that, we will have Gary Zimmerman and then Rick Briscoe. So Angela Halpin. Okay, let's go ahead and go to Gary Zimmerman, and we'll go back to Angelica, probably mispronounced that. Gary Zimmerman. Who I do have down as wishing to testify. Rick Briscoe. Okay, one more time. The chair calls Angelica Halpin. Chair calls up Gary Zimmerman. The chair calls up Rick Briscoe. Okay, let the record show that Angelica Halpin was against the bill, not here to testify. Gary Zimmerman, for the bill, not here to testify. Rick Briscoe, for the bill, not here to testify. Is there anybody else wishing to testify on, for, or against House Bill 918? Hearing none, public testimony is now closed.
Madam Chair, could I do 1407?
Yes, sir. The chair calls up House Bill 1407 and turns to Senator Hughes to explain the bill.
Thank you, Madam Chair and members. I'm pleased to present House Bill 1407 from Representative Schaefer in Senate District 1 in my district over in the House. We know him well, and this bill addresses a loophole, as we many times find ourselves dealing with. Laws change and one section will be amended, but we sometimes miss how it might affect another section. So people come and point these things out to us. And this is about our open carry laws. Right now, open carry law allows a person who's licensed to carry a handgun to do it partially or wholly visible if the handgun is carried in a shoulder or belt holster, right? So if you want to not conceal but open carry, it's got to be partially or wholly visible if the handgun's carried in a shoulder or belt holster. That's the only way you can do that. But if a person removes the holster from their body while in the vehicle, the person's violating the law. There's no defense for the license holder if the handgun is holstered but it's visible in a motor vehicle if the holster's not attached to the person. A rifle or a shotgun can be visible in the vehicle, but a handgun cannot. Again, not likely that this was intentional, but because of the interplay of the statutes, that's where we find ourselves. So House Bill 1407 would just close this loophole by saying license holders aren't committing an offense if the partially or wholly visible handgun was in a holster and the handgun and the license holder were in a vehicle, regardless of where the handgun was on the person. And obviously it may be that depending on the type of holster you have, it could be uncomfortable or even impossible to have it on while you're sitting in your car, certainly if you were going there for a long time. That's what this is about. Does not allow an unattended visible handgun. The license holder has to be in the vehicle with the handgun. That's all the bill does. I'm proud to present it to you and yield for your questions.
Thank you, Senator Hughes. Members, any questions? I have none. We will now open up public testimony for House Bill 1407. The chair calls up Gary Zimmerman. Thank you, sir. Give us your name for the record and who you represent and your position on the bill.
My name is Gary Zimmerman. I'm for the bill, and I'm representing myself and my family. I am for this bill because I do a lot of traveling. And because I do a lot of traveling, I like to carry my firearm with me because you never know for self-defense when you're going to need it. Problem of it is in the vehicles I have, and I have 5 different vehicles, some of the vehicles it's real easy to just simply carry on the side. Other vehicles that I have, it's very, very uncomfortable for me to sit here driving down the road with it on my side. I'm not one that likes to carry it under my arm either. So by having this bill pass, this allows me to actually mount it to my center console, even keeping it concealed or open, and makes it much more comfortable, makes it much easier that if somebody comes and tries to carjack me, rather than me trying to excuse me, Mr. Carjacker, let me get my seatbelt off so I can get to my firearm to protect myself. Easily keep it in the console, keep it in the holster that's mounted in my console. This is a safer way for everybody to do it. As far as I look at it, there's not any negatives to this bill. It just makes it safer, makes it easier for everybody. Doesn't make it non-safer or less safe for a law enforcement officer either. He's going to see it. He's going to know it's there so he can take appropriate action as need be and not have to worry about what somebody's going to do. This is just a wonderful bill. I'm surprised it it's taken this long for it to get filed. I love it. We need it. Thank you.
Thank you, Mr. Zimmerman. Members, any questions? Okay, thank you very much. Safe trip home. The chair now calls up Rick Briscoe. Rick Briscoe. All right. The chair calls up Carl. All right, Islet. Carl. Okay, we'll go back. The chair now calls Rick Briscoe for the last time. Carl Isett. May be botching that, but all right. Let the record show that Rick Briscoe was for the bill but not here to testify. Carl Isett here registers for the bill but not here to testify. Is there anybody else wishing to testify on, for, or against House Bill 1407? If not, public testimony is closed.
Madam Chair.
Is that it?
Yes, ma'am. I just got to. Oh, there's one more on the back. Thank you,
And we're ready.
Mrs. Smith. Well, we've got one more on the back. 1622. Thank you.
The chair now lays out 1622 and recognize House Bill 1622 and recognizes Senator Hughes to explain the bill.
Madam Chair, thank you for letting me present House Bill 1622, filed by Representative Guillen, my classmate in the House. This has to do with early voting rosters. As you know, during that early voting period, we discussed some of these matters in this committee before. Each day, the early voting clerk shows a list of who has voted the previous day and by which method. Some early voting clerks, though, are not complying with the posting requirement. And so House Bill 1622 would incentivize those clerks who comply with the posting by giving voters a way to submit a complaint to the Secretary of State when the law is not being followed. And it gives the Secretary of State the ability to make rules related to this and to design a portal for those complaints to be more smoothly filed. It also requires the Secretary of State to keep a list of clerks who are not complying with this section. Again, we're thankful for those folks who serve. We do want to make sure that everyone is following the law. That's important. This posting requirement brings transparency and accountability to the process, and we need to make sure it's being followed. So that's what the bill does, and I yield for your questions.
Members, are there any questions? Hearing none, we will now open public testimony. Keith Ingram is here as a resource if we need him. The chair opens public testimony on House Bill 1622. Is there anybody wishing to testify on, for, or against House Bill 1622? Hearing none, public testimony is now closed.
Thank you, Madam Chair.
Yes, sir.
Secretary Powell, you ready to go? You good? All right.
Thank you, Mr. Chairman. We have a committee substitute that we'd like to send up at this time.
Thank you, Senator Powell. The chair lays out Senate Bill 919, recognizes Senator Powell, and Senator Powell sends up a committee substitute, Senate Bill 919. Chair recognizes Senator Powell to explain the substitute.
Members, as you may know, in 2015, Texas voters approved Proposition 4, which granted professional sports teams, charitable foundations, the ability to conduct 50-50 raffles in order to fundraise on behalf of their charitable causes. Since the passage of Proposition 4 in 2015, sports teams' foundations have used these raffles to raise millions. A vivid example is the Texas Rangers Baseball Foundation, which was able to raise $1.4 million through these raffles in 2020. They, of course, then went on to use these funds for scholarships, sport promotion, food banks, among other charitable activities. 50-50 raffle tickets have become one of the main tools through which these organizations raise money for their charitable work. Senate Bill 919 would build on the success of these raffles by allowing teams to sell their 50-50 charitable raffle tickets electronically. In the committee substitute, we've added language to make it clear that electronic raffle tickets may only be sold to individuals who are physically in the stadium at the time of purchase. Mr. Chairman and members, I appreciate your time. With that, I'll close and ask for your favorable consideration. We do have a witness here today from the Texas Rangers Foundation, Karen Morris.
Thank you, Senator, and thank you for explaining that, walking us through that. So the substitute, as I understand your explanation, it was perfectly clear. It would make sure that the bill is limited to participation by those folks who are at the stadium, physically present. Did I understand that right?
Right.
Well, thank you very much. And so the chair will open testimony and call Karen Morris. Ms. Morris, welcome. Get situated there and introduce yourself. Tell us who you represent. Give us your testimony.
Good morning. I am Karen Morris with the Texas Rangers Baseball Foundation, and I'm here in support of Senate Bill 919. I want to thank Chairman Hughes for the opportunity to be here, Senator Powell for authoring this bill, and Senator Nelson is actually my home senator, so I appreciate her as well. As I said, I'm the Executive Director of the Rangers Baseball Foundation. Today, I represent the other professional sport team foundations and charities and the millions of those that are impacted by the work we all do. I want to emphasize that we represent the charities, not the sports teams, nor the owners of those sports teams. Each year, in normal times, we as a group raise more than $10 million through the 50-50 raffles, and $5 million of those dollars go back into the community to support our own programs, as well as our long-standing partner charities like the Tarrant Area Food Bank, Buckner International, Mission Arlington, the Houston Area Food Bank, schools, and more. These raffles also help us harness the energy and passion for our fans when our state faces crises like the tornadoes and flooding that have happened so frequently. We immediately use our platform to raise funds to give back to our neighbors. This year alone, the Rangers Foundation's provided funds for more than 5.1 million meals to hungry Texans and given nearly $1 million in grants to emergency relief organizations and agencies like the USO. We've continued to run our programming, but obviously this year was challenging, but we could do more in the future if we're able to pass this legislation. As we all know, this past year has been anything but normal. We are so very thankful to live in the great state of Texas where we can open our stadiums to 100%. The reality is that in some leagues' cases, they are not permitted to do so. In the case of the Rangers, we also realize some of our fans may not be ready yet to attend games in person. So we are seeing a decrease in our ability to raise funds by the people that are in the ballpark. In order to keep our ballpark safe and keep COVID at bay, the Rangers organization has gone cashless, with the exception, as stated, of the raffle. We require our fans to stand in line with cash and hand over a transaction, where we have the technology in the ballpark to eliminate those COVID risks and allow a fan sitting in their chair to purchase that raffle ticket with no additional exposure for COVID and be able to help the charity. We're not here to seek expansion of where we sell raffle tickets. We will be selling them in the exact same places as we're selling them now. All we are seeking is a different purchase method to allow for a safe, cashless transaction and allow for us to raise more money for Texans. Let me be clear, this bill is not about raising money for sports teams nor sports owners. This bill is about the 14 young people at our youth academy in West Dallas that received college scholarships to play baseball and softball, becoming the first in their families to attend college. It's about the $40,000 we gave to teachers to help them prepare their classrooms in these COVID times. It's about the grants that we've made in cities as big as San Antonio and as small as De Leon. That's what this bill is about. It is about charity. It's not about the sports team owners or sports teams, and it's about creating an easier method to purchase those tickets.
Ms. Morris, thanks for your testimony. Senator, is there any questions for the witness? Thanks for what you do. Thanks for your testimony. The chair calls Rob Kohler. Kohler, come on down. We'll have the spot ready for you here. You know how to do this. Introduce yourself. Tell us who you represent and give us your testimony. Welcome.
Thank you, Senator, very much. My name is Rob Kohler. I'm here representing the Christian Life Commission of the Baptist General Convention of Texas. And I'm here to testify against this bill. I visited with Senator Powell's staff and shared some of our concerns. And I want to share with the committee that I'd written several sessions ago when this 50-50 raffle first came up, and it was 2015. It's amazing how time flies around here. But I was approached by Buddy and Jay about the professional sports raffles back then. And our number one concern back then was, and remains today, is taking a known game and creating an electronic record of it electronic facsimile of a game of chance. We have spent over, at that time, maybe 10 years where we faced some very powerful people in this state that wanted to put video lottery terminals in the horse tracks. Well, video lottery terminal very simply is electronic representation of a scratch ticket. The pull tab, instant pull tab bingo, we spent many years, and Senator Armbruster had some mighty wars on the Senate floor where they tried to take a pull tab ticket and make electronic record of it. The game sweepstakes that we all know. Sweepstakes has been, whenever they successfully argued that a sweepstakes and turned it into electronic record, that's the 8-liners that we see all throughout this state. They're sweepstakes machines. And lastly, our concern involves ending gaming laws, the unintentional piercing of Class 3 in this state. Eventually what happened is we were told the sports teams had no desire to go to electronic. They simply wanted paper form, and we worked with them. In fact, I vouched several times for the raffles in the Senate. We watched them implemented. I was very proud of how they were implemented. The paper wager in the paper process and the causes we thought were very outstanding. But what we're talking about now is not that. This would bring some firsts to the state of Texas, the wagering over the phone, the wagering over the internet, the use of a credit card. We don't allow that at all in our enterprises. And the electronic facsimile of a game of chance, as simple as that sounds, all we want to do is let our participants that come to our stadiums, instead of getting out of their seats to place that wager over the phone, that is a Class 3 game. And just on a cautionary note, not to take any more of your time, but in 2005, in the state of Florida, the horse industry there, who was successful after many, many attempts to try to get VLTs into their horse tracks, finally had success, and they had county-by-county referendums in only 2 counties. One county voted it up, the other county voted it down, and on that action, that pierced Class 3 gaming in that state. And the Seminole tribe, at the time, which is the equivalent of the Kickapoo tribe in our state now, was able to go directly to the governor, negotiate a compact, and they're now one of the largest gaming companies in the world. They purchased Hard Rock. So in closing, we're against this bill and appreciate the opportunity to testify.
Ms. Cole, thank you for your testimony. And I've got a couple questions, but any questions for the witness? I don't want to hog the time. So let me ask, and of course, many people here have concerns about expanding gambling. Have you seen the committee substitute?
I have, Senator, and I visited with them yesterday, and what my understanding is they restricted it to the facility. It was in the House, it was statewide. And unfortunately, because of that action, it's still creating an electronic facsimile of a game of chance. And from our experience of looking at other states, it doesn't matter, and there's not a direct of how you pierce that Class 3. We would tell you, in my experience, that that's a Class 3 game.
Well, thanks for that, and your position is clear, and no one wants to muddy that. I want to be sure I understand. So you don't find the committee substitute any less objectionable than the filed bill? Because many of us who don't like expanded gambling do.
Sure, and you were a leader. I mean, back in the House when I mentioned the VLTs, I mean, you were one of the leaders in the House. But I will tell you that just restricting it to inside, you still have it's really the biggest hurdle is the electronic facsimile of a game of chance. That triggers Class 3. And a lot of the misconceptions about Class 3, Senator, if I can just give you a little background for folks say, well, what's the big deal, Rob? Okay, in our state, our Class 2, the only tribe in this state that's recognized by the Indian Gaming Regulatory Act are the Kickapoos in Eagle Pass. So they say, okay, you pass this bill. What's the big deal? That means that they could do the same thing on their reservation. the fact is that that's simply not true. What happens is then a tribe, like the Kickapoo, the Class 2, as soon as that bubble is pierced to Class 3, and just to let you know, the state of Texas is one of the few states remaining that is Class 2 federal gaming. If that bubble is pierced, however it's pierced, that gives the only Class 2 tribe in this state the opportunity to go straight to the governor's office to negotiate a compact. In negotiation of that compact, if they don't reach agreement and goodwill, the Kickapoo are able to go directly to the U.S. Secretary of Interior. And what's negotiated is an exclusivity agreement. It's not defined. That exclusivity agreement really has two components. It's a geographic, where can they run games, and the type of games. So like in Florida, where the Florida legislature, they very simply said, we want VLTs in the horse track. We're going to allow the people to vote on VLTs. When that vote was taken, they had no idea what kind of box they opened up. And that allowed the Seminole tribe to go through federal law and start operating casino games. As simple as that is sitting in the stadium and placing a wager or electronically, I will tell you from my experience, that's electronic facsimile of a game of chance, which is a Class 3 game. And if you're interested somewhat to get an idea, the Kickapoo, I have tremendous respect for. What they testify through my experience, they don't guess, they know what they're talking about. And you get a little idea of what their geographic consideration of as an estate is if you look at the constitutional amendment that they file every year, every session. And in that, what they say is that they consider 300 nautical miles where they can put a casino. Now, 300 nautical miles, Senator, nearly gets you out to Tyler. Doesn't quite get you to Tyler. But 300 nautical miles gets you to Houston, basically goes to College Station, all of South Texas, and all the way to Lubbock. So I share that with you just to know it's not a simple extension, unfortunately, with the gaming laws, and we've learned from other states. There truly is a real reaction to actions, and we believe that this bill presents that.
Thank you for your testimony. Senator, is there any questions for the witness? Thanks for being here, Ms. Kohler. Thank you very much.
Thank you.
Senator,
I
yes.
do have a comment on closing.
Oh, please. We recognize Senator Powell to close on the bill.
This bill doesn't expand gaming in any way. We all, as legislators, hear that litany about the slippery slope.
Senator Powell, is your microphone hot? And as you do that, and I didn't formally, so let me close public testimony and now recognize you to close on the bill. Thank you.
Mr. Chairman and members, as legislators, we constantly hear the slippery slope argument. This bill in no way expands gambling in the state of Texas. This raffle is already being conducted. All we are doing with this legislation is changing the manner in which we collect the funds for the raffle. It protects our citizens from any further exposure to COVID-19 and other issues. It allows the participants in the raffle to have a simpler methodology for purchasing their raffle tickets. It in no way pertains in any way. It's secondary to the professional sporting event that's taking place and is not influenced in it by any in any way, any shape, form, or fashion. And I would point out today that electronic gambling doesn't support charitable efforts in any way. The real purpose behind this raffle is to raise funds for charitable purposes. Our charities in the Metroplex, where we have already been doing these raffles for many years, have provided food for our citizens through charitable efforts during the COVID-19. So I think that the important thing here is that we're expanding our ability to get back to normal and raise those normal charitable funds that we have been raising for many years. So I ask for your favorable consideration of this bill.
Thank you, Senator Powell. Any questions for the author? Thank you, Senator. Senate Bill 919 be left pending at this time. The chair now lays out House Bill 1082 by Representative King and recognizes its sponsor, Senator Safferty, to explain the measure. Senator?
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 1082 by Representative King relates to the availability of personal information of an elected public officer. Members, statewide elected officers and members of the legislature can withhold personal information from public disclosure. Local officials, however, are not afforded these privacy protections. House Bill 1082 would enhance security for local elected officials by preserving their confidentiality in the same manner as state officials. Generally, then, the bill adds local elected officials to those whose personal information is confidential and documents subject to the Public Information Act and in tax appraisal records. In other words, they would be treated just the way we are. Thank you. That's all it does.
Thank you, Senator. Any questions for the author? Very good. We'll open public testimony, and no one has, no one has expressed their intent to testify on, for, or against the bill. No one's electronically registered to do that, so I'll ask anyone present wishing to testify on, for, or against House Bill 1092, and seeing none, public testimony will be closed at this time, and the bill is left pending.
Thank you, Mr. Chairman and members.
Thank you, Senator. That concludes our posted agenda. Any other business for the Senate Committee on State Affairs? Very well. The committee stands in recess up to the call of the chair. Good morning.
Thank you.